Hi, everyone. Welcome in. We are going to get started in just a minute with our legislative update for Oregon. I see a lot of you that normally join our webinars, so thanks for coming back. And if you're new, welcome. We are going to go through and save questions until the end. So we would love if you have questions as we go ahead and enter them into the chat. And at the end, we'll go through that and get to as many as we can. During the presentation, please make sure to keep your microphone on mute so that we can hear Karna and Rich the whole time. And again, if you have questions, just go ahead and type them in the chat. Thank you.
Good afternoon, everyone. Thank you for joining us today at Weill Fotheringham. We are happy to bring you the legislative update for the 2021 legislature, which just ended couple weeks ago, and we have the bills for you today. My name is Karna Gustafson. I joined Weill Fotheringham January of this year. I have been an attorney for 26 years with a prior law firm, and I'm happy to join Rich today and Weill Fotheringham. So thank you again for attending. Rich?
Rich Weill, and I'm a former legislator with the Oregon House of Representatives. So I'm particularly interested in how our legislation affects homeowner associations. I'm retiring, I'll put it that way. I continue to have some active practice, but I'm looking for ways out every chance I get. Today, Karna and I are going to trade off on these bills. Some of them relate more to HOAs than others, but I hope that if you have questions, you'll make sure and ask those. We're going to start with the Senate Bill 185, which is the Nonprofit Corporation Act, and a little bit of history on this. For about 15 years, the folks that primarily deal with nonprofit corporations other than homeowner associations have wanted to make sweeping changes to the Nonprofit Corporation Act, traditionally to make that a little bit simpler for members of the board of nonprofit corporations to operate, ways to dissolve a nonprofit if it just isn't operating very well anymore, et cetera. But the problem has always been there are homeowner associations that are also nonprofits, and avoiding conflicts between the two has been an issue for many years. This Nonprofit Corporation Amendment, Senate Bill 185, makes it clear that the Condominium and Planned Community Act will trump the Nonprofit Corporation Act in the case of those HOAs that are organized as nonprofit corporations. And so it really doesn't have a lot of relevance to homeowner associations. There are a couple of small items in there that may be useful for homeowner associations, but they're really not worth going into any detail in the amount of time that we have today. Suffice it to say, if your HOA is a nonprofit corporation, start with the Planned Community Act and the Condominium Act, depending on what you are, and then look to the Nonprofit Corporation Act if you think there may be something there that could be helpful. Karna?
Yes, thank you, Rich. I appreciate that. Yes, there is actually information in both the Planned Community Act and the Condominium Act on which actual sections apply if you are a nonprofit corporation. I think nowadays most are supposed to be nonprofit corporations, but you may find yourself being one of those that's still unincorporated. So hopefully I am sharing my screen. I apologize if other things pop up since this is an active computer, and so occasionally you might see some other actions popping up. Relating my bill next is Senate Bill 220 relating to notaries. As you may know, document amendments, bylaw amendments, CC&R amendments are required to be signed and notarized. This bill allows for remote notarization. Before, you had to go down to your bank and sit before a notary to sign a document. This allows a form of remote notarization pursuant to the rules in the bill. So if you find yourself needing some sort of remote notary, we have access to this bill that now is effective. Rich?
Next one is Senate Bill 329. This was the big kahuna of the session as far as the HOA industry was concerned and things that we wanted to see happen. Obviously, COVID brought about an acceleration of interest in making sure that we could conduct business via electronic meetings, and Senate Bill 329 made it clear that homeowner associations, both condominium and planned communities, are able to do so, and it provides for specific means of giving your notices and how those meetings are to be conducted. We're all very used to it now, and I think we're going to find that this bill is going to be implemented without any hitches.
Yes, we're excited about this bill. It declared an emergency, so it is now effective. So as soon as Sunny Day happened at the legislature, it became effective. So you can continue to have your board meetings and your annual meetings electronically. There are some requirements for notices and certain things that you have to provide. It also allows for you to do hybrid meetings. So if you want some people in person and some people on an electronic format, you may do that as well. So the next one, Senate Bill 391, accessory dwelling units, or what we also fondly call ADUs. This bill allows ADUs in the rural counties. There was a previous bill in a previous session requiring jurisdictions to allow ADUs inside the city boundaries. This one relates to rural communities. We were successful as an advocacy group to require, if a ADU is built, that it still has to comply with all of the rules relating to your CC&Rs. So you have that still a requirement. There are several limitations.
Sounds like
Very
maybe,
last minute.
did you get cut off, Karna? Or are you still going?
It says my internet is unstable.
And
Can you hear me?
I see that the connection has been lost, it says.
Okay, I'm back.
Okay, good.
I'm back. Something happened. I got to pull up the screen share again. Audrey, can you help me pull the screen share back up?
There you go. So just go to your PDF again, if you can find it.
I think it was. Anyway, I can keep talking while I'm looking for this PDF. The Senate Bill 762, which was the fire bill, was adopted at the very last minute at the legislature. And it requires certain fire hardening if you're in certain zones, which the ODF and OSU will ultimately fire map the entire state. They're required to do that by June of next year. And there we go. So yes, so there's some very specific rules on the size of the ADU, the structure of the ADU, and fire hardening of the ADU. But until that fire mapping is done by the ODF, Oregon Department of Forestry, and OSU, we won't see those ADUs quite yet until next year. And then when Rich jumps to the next one, I'm going to try to figure out how to screen share again.
Well, let me just tag on you there, Karna, while you pull that up. This applies to every county that has a rural residential zone, and that is virtually every county in the state. I believe there may be one county, Multnomah, that doesn't have rural residential zones, but everybody else does. And this would apply in all of those rural residential zones, which are several. They're not just a single zone. The other thing I wanted to say about this is those of you who deal with planned community declarations, you want to be careful if ADUs are added in a planned community. It may be that you need to look at changing your documents so that appropriate allocations of assessments may be made. If assessments are based on utility costs, for example, and somebody adds an ADU, you may want to look at the possibility of increasing the allocation to that lot for its common assessment. A lot of people are also asking the question of whether this would affect voting rights. If I now have 2 houses on my lot versus just 1 house on my lot, should I have an extra vote? The answer is probably not. But again, you may want to look carefully at documents, and in some cases, documents may need to be amended. This ADU provision in planned communities is one that potentially has complicating effects for how your operation is conducted. Did you figure it out, Karna?
Not quite yet. I think I have to log back in.
Karna, will you email it to me really quick?
I don't have the ability to access email, so that's part of my issue here.
Go down. Yeah, if you go down to the bottom of your screen, you can access your email and email it.
Yeah, I'm not in. So, Rich, do you have it? You can email it to her?
Yep, I'll email it while you talk.
Yeah, for some reason, it's not letting me back in. Okay, so the next one is on land divisions, which is Senate Bill 458. This actually allows for the middle housing that was approved in House Bill 2001 back in June of 2019 by the Oregon legislature, which allows duplexes, triplexes, quadplexes, townhomes, and cottage clusters to be built on any lot that now allows for a single family home. There was a lot of news coverage over it saying that the news coverage was eliminating single family zoning, which in somewhat respects it did. That's what House Bill 2001 did. This Senate Bill 458 actually allows you to actually divide the land. So if somebody wants to put a duplex on a lot, they can divide that land and allow for each side of the duplex to be home ownership, so that the duplex won't be just rentals. It can actually be separately owned by 2 different parties. Again, this bill does provide that assessments shall be assessed against each side once those become 2 separate lots, or in the case of a triplex, 3 separate lots, or in the case of a quadplex, 4 separate lots. Townhomes and cottage clusters would also have to pay the same assessments and vote the same as everybody else. Now, the next question you're probably going to ask, or will be put in the chat, is what if our CC&Rs prohibit that type of middle housing being built? If as of January 1st, 2020, your CC&Rs say every lot is limited to a single family detached home, then you're safe. You cannot now amend your documents to prohibit the land division or prohibit middle housing. So that's one of the things House Bill 2001 did, was prohibit associations from going in and amending their documents to prohibit middle housing. So not only do you have to allow the middle housing, but you then have to now, under Senate Bill 458, allow those middle housing products to be divided into separate ownership. But we were able to negotiate the fact with the bill sponsors that they have to pay the same assessment. So that lot may have been only paying 1 assessment if it was a single family home, but if it becomes a duplex, triplex, a quadplex, it now has to pay the equivalent number of assessments, but you also have to add that same number of votes to your community. Okay, next.
Okay, the next one's kind of a weird one. I'm just going to take a second on it. Senate Bill 765 also deals with notaries. What happened was in the first special session of the legislature in 2020, we had an emergency bill passed that allowed for some of the remote notarizations, and it had some funny provisions in it that didn't quite track with the later bill that we had adopted this session. All Senate Bill 765 did is repeal some of those weird sections and make it all consistent with the new bill that allows remote notarization under certain circumstances. And again, I'd urge you to read the bill, the original bill, I think it's 185, that allows for that remote usage, because it's not absolute. There still are some rules that need to be looked at. Okay, Karna, the next one's construction defect. Are you ready for that one?
Yep, absolutely. Well, it's called a construction defect. The bill was amended to remove all references to construction defect. It no longer applies. The intent of the bill originally was to limit the statute of limitations on construction defect claims for projects that were smaller, say 20 units or less, where the builder developer had gone through extra classes in order to qualify to build such a product. And in turn, the construction defect time limitation would have been shortened. That all was removed from the bill. The ending result is just the extra certification and the extra classes a builder can take to become what's called a master builder. And it also changed the location of the master builder program to the Construction Contractors Board, which was previously in another part of the state bureaucracy, and it has now been moved. So the only thing left in the bill is relating to education of builders and developers, and making it possible for them to become a master builder.
So my observation about this bill is that, once again, we have the construction industry really trying to limit the number of claims that can be made for poorly constructed buildings, particularly in our case, condominium buildings. But the legislature was not inclined to go that direction. And we're probably going to see these efforts over and over and over. It's important that every homeowner association be very sensitive to the fact that their claims, if they have them, may expire, and every legislative session may cause that expiration to be accelerated. But again, as Karna said, this time around, what we ended up with was more training for developers and contractors, and no erosion of an HOA's rights to bring a construction defect claim.
You're next on possession after execution shall, Senate Bill 829.
Yeah, so I'm just going to make a quick observation about this one. In a world of difficulty as a result of COVID, equity conversations that became paramount with respect to every legislative consideration this session. Essentially what we got was, it's more difficult to get folks out after you've executed on a mortgage foreclosure. The real takeaway for HOAs is that if you have to foreclose on an unpaid assessment and you actually end up taking the property back as an HOA or as a condominium association, getting the tenant or the remaining owner out of that unit may be more difficult than it was before. And I can tell you that this is one where you simply are going to have to go through a significant legal process to get somebody out even after foreclosure has occurred.
Thank you, Rich. On to the House bills. As we all know, there are Senate bills and House bills. And if you note in the presentation, some of these have emergency clauses and some of them don't. If there is an emergency clause in a bill, it becomes effective immediately after sine die, which is the end of the legislative session. Some are effective at a specific date, and some wait till 90 days after the end of session. Some actually declare a delayed implementation date. So you'll see different dates on when these bills are effective. And we'll try to mention when they're emergencies or not. In this case, House Bill 2009 relating to foreclosures declares an emergency. This has to do with the moratoriums on foreclosures, preventing lenders or previously HOAs from pursuing foreclosure of a lien. This new House Bill 2009 actually only relates to lenders of residential mortgages. So it no longer applies to HOA lien foreclosures. So while the moratorium is up on HOA lien foreclosures, it's still probably not exactly the best process in the world as it used to be to removing a person for non-payment of assessments. But it is now available to you. We have collection specialists at Vial Fotheringham that can walk you through that if you are interested in pursuing a lien foreclosure in one of your HOA situations. Rich?
Lawful units of land, this is rarely ever going to affect a homeowners association, but for certain planned communities that have large lots, one of the things interesting about Oregon law up until now is that you could put a mortgage on less than an entire lot. And if that mortgage were foreclosed, it essentially divided the lot. And the question was, if you divided the lot, did that mean you now have two lots and you have potentially another building site? This makes it clear that those judicial boundary changes are not going to affect what would have been in place prior to that judicial boundary change as a result of foreclosure, et cetera, with respect to the land use application. Again, it's not likely to occur except in a very, very rare occasion on a planned community that has extraordinarily large lots.
Thank you, Rich. The next one, House Bill 2341. If you could advance the slide, please. 2341 is a result of the devastating wildfires that we had last year. There were thousands upon thousands of homes lost in the devastating wildfires, and we are now starting our wildfire season this year. Hopefully it will not be nearly as bad as last year. This deals with taxation, real estate taxation of those damaged properties. So if your house no longer exists and the tax declared covered by the state of emergency declared the Fire Act of God under the Emergency Conflagration Act, then your property taxes are going to be prorated. Again, not sure. It's going to be a limited application depending if your property was affected by the wildfires. It has the possibility of applying to other acts of God in the future, but for right now, it was intended to deal with the fire season we had last year. Rich?
House Bill 2409. Everybody who's been asleep now, wake up. This is a big one. This one essentially makes it very much more difficult for homeowners associations to do common application of pesticides with respect to those portions of the association that they're responsible to maintain. So, for example, HOA has to maintain front yards. And now, if they are going to put any pesticides on in the maintenance of that front yard, they got to give notice to owners, and owners can opt out. And then the association doesn't get to put the pesticide on. It makes it less likely that we're going to have consistency in homeowner associations. We had a lot of conversation as a advocacy group with the proponents of this bill, and we didn't get quite as far as we hoped, but we did get the requirement that if the HOA can't do the maintenance, that the owner will be required to maintain it in such a fashion that it continues to have a consistent look essentially with the rest of the association.
Correct.
Karna, you should probably weigh in on this one too. You were very involved in this one.
Yeah, there was a lot of back and forth with the bill sponsor on this one. We tried to make the owner who wants to opt out pay for the increased cost an HOA might experience if the landscape contractor charged more for having to monitor who gets the pesticide and who doesn't. We were unsuccessful in that. So the association is going to be eating the cost of if there's an upcharge from your landscaper because there's not an even application of these pesticides. It was unfortunate because some associations were already allowing people to opt out of the pesticide application. And unfortunately, this particular bill sponsor had a friend that their HOA did not prevent them from opting out. And this is how we ended up with legislation requiring associations to allow people to opt out. Sometimes bad facts make bad law, and that's what happened in this situation. Also, with the advent of COVID, our ability to testify in front of the legislature was severely limited. And so we weren't able to be in the building and talk to legislators about potential ramifications of these types of bills. So that's what we ended up with. It is not effective until January 1st, 2022. So this was not a declared emergency. The next bill.
I'm going to make one last observation about this one, Karna. It blew my mind that we got toward the end on this bill and it was being debated. And I don't know how it happened, but this bill got wrapped around the axle of the racial equity and diversity argument. And somehow we got accused in our efforts to kind of make this work better for associations of being guilty of racial and diversity bad statements. I don't know how having pesticides on your lot affects one racial group more than another, but it's just an example of how this session went.
Another bill we're going to talk about later that didn't pass had the same reaction, and we'll talk about that later in the presentation. But yes, it was diversity, equity, inclusion was a theme throughout this legislative session. Everything that went through or didn't go through was looked at within that lens. And so you'll see some interesting things that have happened or didn't happen based on that review by the legislature. The next one is an example of that, which is discriminatory language. Associations are now required, okay, pay attention everybody, if you weren't listening to the pesticide, you better be listening to this one, because you have an obligation before December 31st, 2022 to review all your governing documents. And that's not just recorded documents. That's rules, resolutions, regulations, ARC guidelines to determine whether or not there's discriminatory language found in them. And if you can record something that says that you've done this review, or you can actually amend the documents if you find some discriminatory language with a board vote only. It does not require you to go out to the homeowners to get an amendment done if you do find discriminatory language. Most discriminatory language was removed back when another bill a decade or two ago passed that limited any application of discriminatory language. So there's probably not a lot of language left. But in another bill, and I don't have the number, I think we're going to get to it later, deals with gender equity and some other types of occupancy requirements. There's some discussion of how that affects this discriminatory review as well. So if you're not going to do it yourself, please do not wait until November, December to have your attorney do this for you. This is something that every association is required to do. And I suggest you get on top of it sooner rather than later because, for example, I already have 5 associations in review of my own clients that have asked for this review. And Viofotherham represents thousands upon thousands of associations. So for us to be able to get through all these in time, we need to know right away if this is something you want us to do for you. Rich?
One other thing on that, Karna, in 2017, we actually did pass a bill that would allow the board of directors to remove discriminatory language from a declaration without a vote of the owners. And so that's already in law, or was in law already, and that's going to have to be used in many of these cases to get rid of that language.
Yeah, in this case, this bill expands the ability of the board to do other documents and not just a declaration. Right. So, because it affects every set of documents that you have that govern your association.
All right, this next one, House Bill 2550, kind of cracks me up because I'm one of those guys that has always tried to develop a relationship with whomever I'm buying real estate from, whether it's residential real estate or commercial real estate. And so I routinely, when I'm buying real estate, will write a letter or call them on the phone. Real estate agents hate me because they always feel like I'm trying to go around them. But the reality is often a good transaction depends on some kind of relationship being developed between a buyer and a seller. Well, you can't do that anymore. And this one actually came right out of the governor's office. And I heard her talk about this. She was really worried that if buyers kept sending these love letters to sellers, that they would figure out, oh, this person's white or black, this person has an education or doesn't have an education, this person's gay or straight, this person's married or not. I'd really like to sell my house to somebody that has children. The governor was really worried that that would create a situation where we would have discrimination against people occurring on the part of sellers because they got a letter from the buyer. So now we got a law that says the buyer can't send a letter to the seller. And that's that.
Yes, it was very interesting. I'm friends with a lot of realtors who use those love letters, especially in today's age where there's multiple offers and the seller has many to choose from, and they use those love letters to try to get their offer be to the head of the game, and no longer are these allowed. There's a lot of upset people that they no longer can do this anymore. So advancing the slide, the next one is occupancy 2583, relating to maximum occupancy. Before I go into the actual bill itself, there's already rules by HUD that prevent you from limiting occupancy under certain circumstances. So you can't limit occupancy less than 2 persons per bedroom. A den, even if it doesn't have a closet, could be considered a bedroom. A bonus room could be considered a bedroom. A dining room could be considered a bedroom. So you have to be very, very careful on limiting occupancy. If a client of mine, an HOA client of mine, says that they wanted to go down that road, I would try to talk them out of it. It's just not worth it today with the discrimination rules. So this one goes a little further, relating to establishment or enforcing occupancy limits based on familial relationships. So if you have a partner and not necessarily a married situation, this prohibits enforcing that. If the partner is not necessarily on the deed, they're going to prohibit you from trying to enforce that person's removal from the unit. So this goes probably a little bit further than what the federal HUD regulations are. Rich?
House Bill 2809 potentially has an effect on homeowner associations, but we hope the question never arises. Here's the background on this. My brother John is actually the public works director down in the Medford area. And when they had the fires in Medford, Phoenix area last year, they lost 3,000 dwelling units. Some were mobile homes and mobile home parks, but many were single family homes in residential subdivisions. In many cases, there were zoning regulations that prohibited a person to live in their recreational vehicle on that lot for any period of time other than like a day or two. Well, in fact, a lot of those folks had no choice. They had to just move, and in fact, some were FEMA financed. They had to move a temporary dwelling unit, a trailer, onto their lot in order to just have a place to live. This law basically says governments may not prohibit the use of a recreational vehicle on a property where a natural disaster has made the primary residence on that property uninhabitable. The question is, and it never got resolved, the law says government, it doesn't tell us whether or not that would apply to an HOA. So if you got a planned community, for example, that prohibits someone from living in their travel trailer on a lot on the in the HOA, and you end up having a fire, we don't know for sure whether or not this law would override your prohibition. Again, hopefully that'll never occur. My guess is that if it did occur, the law probably would be construed to override a CC&R that prohibited the use of a recreational vehicle for housing for up to 24 months on that lot.
So a couple more issues on that and thoughts that I have on that. We never want HOAs to be considered government or quasi-government or anything else, because that brings in a whole other host of rules and laws that then would apply to HOAs. So we never like to argue even remotely that a HOA is a somehow quasi-government entity. So out of best practices, it would be my advice to any HOA trying to enforce and prevent a recreational vehicle on a burned up lot that to not go there. That's just public relations nightmare. It will get you on the 6 o'clock news. And if we've heard anything else, and you don't take away anything else from this presentation today, you do not want to be on the 6 o'clock news. Do not try to enforce a restriction against recreational vehicles on a burned out lot. That's just my 2 cents.
Now, Karna's absolutely right. That would force the question of whether or not this local government prohibition applies to HOAs, raise the question of whether an HOA is a local government. We don't want to go there at all. And as Karna says, you look bad if you're making sure that somebody doesn't have a place to live.
Right.
Okay, well, let's advance the screen there, Terry.
All right, the next one's mine, House Bill 2884, extending the time for recording a petition plat. This really shouldn't have any effect on HOAs. It's one what we put in these sheets and the bills we follow are bills that potentially could be amended to affect HOAs. So we do follow more bills than what actually end up applying to HOAs. So this one, while it extends the time for recording a petition plat, it should never actually end up affecting an HOA. So Terry, can you forward the slide, please? No, it's Audrey. Audrey, could you please forward the slide? Thank you.
All right, this is one that Karna mentioned before, House Bill 3041, removes gender identity from the definition of sexual orientation. And you know what, Karna, I don't even begin to understand this bill. Could you explain this for us, please?
So
I never did get it.
Well, I think they wanted to make it the gender identity being something that's not part of sexual orientation, they don't want it to be part of gender identity. They want it to be something separate by itself. So while they removed it from the gender identity, they made it something standalone. They also said that sexual orientation, they removed the provision that sexual orientation is not a physical or mental impairment, qualifying as a disability, which was, again, very interesting decision-making on their part. This was an emergency, but again, reading this bill in conjunction with, I think it was 2534, yes, 2534, you kind of need to read these two together to see what kind of potential discrimination may be found in your documents. So it's not just looking for, we prohibit Asian Americans from living in our subdivision. It's more nuanced than that in what you're going to need to look for into removing the discrimination from your documents.
Again, on this one, if you have questions, do not call me, call Karna, because I have no clue what this really does.
It was this one was a very last minute bill. A lot of us didn't get to digest it. Again, because of the way the legislature worked this under COVID, we weren't allowed in the building. Testifying was very difficult. It was a delayed testimony. So sometimes technical difficulties prevented testimony. So it was very difficult to understand this one and what the background was in order to get it passed. On to technical changes. I'm not sure this really applies necessarily to HOA, but we monitored it anyway. Just it has some grammar, punctuation, obsolete provisions. Again, this is just to various different aspects. A couple of provisions in the Planned Community Act and Oregon Condominium Act were changed, but it was just, again, grammar, punctuation, obsolete language, nothing that really necessarily can apply to your everyday lives. Rich, childcare?
Childcare, a simple statement, basically, child care facilities have been expanded once again, and they keep getting expanded. It seems like every session, but we can't prohibit child care facilities. We just basically can't prohibit child care facilities.
Right, and there was already a provision in the Planned Community Act that prevented HOAs in a planned community from prohibiting them under certain circumstances. This one just, we were monitoring to see if they added condominiums. At this point, condominiums are not required to. The question is, if you're a condominium and you're a single family detached home, could you end up under there? Maybe. So again, childcare facilities are a huge problem across Oregon. They're dwindling fast, which prevents parents from working if they need to or want to. And the legislature has been very active in trying to help governments and other places allow them and make the restrictions less on creating childcare facilities. Okay, House Bill 3272, insurance damaged properties. This was a case where the legislature wanted to get involved between the contract between you and your insurance company. This is also a bill that kind of came out of the fact of the fires last year and the ability of homeowners to replace their home that was damaged in the fire. Extending time frames, declaring emergencies, living expenses. Again, it doesn't really necessarily apply to an HOA, but it talks about trying to replace that property. It'll be interesting to see if we see litigation over this because it does require the insurer to do certain things which were not part of their original contract with the homeowner. Rich, do you have anything more on that one?
No, I don't think so. And the last one we're going to talk about here is, again, probably not relevant to most associations because it deals only with tax, what am I trying to say? It deals with low-income housing that got a tax benefit and are organized in the form of a condominium. Owner-occupied condominium units burdened by an affordable housing covenant basically says that 27% of the assessed value of that unit is exempt from any property tax. Probably not going to apply to anybody who's on the call here today.
So the next couple down from the page, Audrey, are bills that did not pass. One related to budgets, one related to actions taking retaliatory actions against owners that complained against other owners of the board, and the other one would have prevented the association from regulating hens, bees, and produce being produced in and on a lot. We're not sure, while these went away this session, they may come back. And so we want to bring them to your attention that it's possible we may see these come back around again. But for this session, they did not pass. I do want to allow time for questions. So I didn't want to go over too much about the bills that did not go forward. Just wanted to bring them to your attention that there is never a shortage of bad ideas when it comes to the legislature.
I do want to make one other observation before we go to questions, and that is that we got criticized as a CAI got criticized. Some of us other that were doing some advocacy got criticized because we didn't oppose some of these bills vehemently enough in the minds of some folks. I think it's a really important thing for people to understand that this process is one that is really built around relationships, and we try hard to maintain good relationships with legislators so that we can really make sure that we are heard on the important issues. Not that these aren't important issues, and they really are important issues, but please recognize that sometimes it really pays for us to work with legislators rather than just flat out oppose legislators. And that happened this session on a couple of these bills.
Yeah, especially with the hens, bees, and produce. This was one that also we were accused of discriminating against people because we were opposing the bill. You know, there were some serious concerns about the bill, the way it was drafted. Well, it says hens, bees, and produce there. You could have seen homeowners raising cattle in their yard, sheep, any other number of things. Because of the way the bill was drafted, it did not limit it to hens, bees, and produce. So we were very concerned about other types of food production being done in a planned community. So there is also facts and other situations that you guys might not be aware of when we're working on this legislation as to why we may be opposed to certain legislation.
And just finally, look at the Oregon Legislative Information System. If you just Google OLIS, O-L-I-S, that will tell you every bill, where it's at, when the next hearing is, give you an opportunity to be heard on it. And OLIS is used in every legislative session. Everyone who has an interest in legislation should be familiar with using OLIS.
Yes. All right, well, that gives us a few minutes for questions. Audrey, are you going to control the questions and let us know what's up first?
Okay. So Linda Brown early on asked, how are rural counties defined and where can I find that information?
And the answer to that is all counties are affected by this rural residential designation. So it's going to be your county. I can almost count on it.
Anything outside the urban growth boundary is basically what this rural ADU applied to. So, you know, there's a invisible line around every city. If you're inside it, this particular House bill, Senate Bill 391 didn't apply to you, but previous legislative sessions did have ADU legislation that requires your cities to allow you to build an ADU that under certain circumstances. So you'd need to go back and look at that.
Okay. Next question, Hernando Converse asks, we have scheduling spraying against pests 3 times a year. How does the House Bill 2409 affect this? Owners are informed of it.
Owners
You
are
just
going to be,
required, go ahead,
Yeah.
Rich.
owners are still going to be informed of it, but now you're going to have to require them with a notice each time you spray to opt out. And if they opt out, you've got to let your provider know that they cannot spray that lot.
Okay. Jane Edwards asks, is use of chairman in bylaw discriminatory? House Bill 2534. Jane, if you're on, if you'd like to unmute and clarify that question, you're more than welcome to.
Well, you were talking about discriminatory language in documents. So we have one of our officers as a chairman, which is, an old term. So is that discriminatory as opposed to using chair or chairperson?
Personally, I don't think so, but this bill would allow you by a board vote to change that if you would like to.
Okay, thank you.
And I'm going to suggest that you do. I got to tell you, I am surprised at how often I'm hearing now the chairman language be criticized. So chairperson or chair is my suggestion to you.
Yeah, there's also documents drafted not that long ago that uses she and he. The preferred language is they or them. And that the reference to she and he in your documents could be considered discriminatory. And you may want to record a document that just says that all of those are removed and replaced with they or them.
Perfect. Okay, next question is from Linda Brown, specifically for Karna. Why do you not want HOAs considered a government or quasi-government? According to Evan McKenzie, who has been on PBS recently and is an author of Beyond Privatopia, Rethinking Private Residential Government, that is what they are. Linda, if you'd like to unmute yourself and kind of explain that question, you're more than welcome to.
Basically, that's it. As I understand Evan in his book, he does think HOAs are a private residential government, and he is, promotes more transparency as well as
I am absolutely.
So I wanted to understand why you think it's not. That's basically the question.
It's CII National's stance that. Oh, my internet connection is unstable. Can you guys hear me?
Yes, we're fine, Karna.
Okay. It's CII's National Community Associations Institute's National's position that HOAs are not government entities. There are a whole host of laws that would apply to HOAs if they were considered a government. And the volume and the education we would have to go down to educate all of our boards who now became government persons would be astronomical. Anywhere from right now, free speech does not apply to an HOA. You can regulate speech. A government cannot. That's just the number one example. The regulations and rules that you restrict may also become under question of whether or not you could enforce those because a government cannot. It's just a can of worms to go down that route. I have no problem with transparency. I have no problem. We have open meeting rules that are similar to governments that require you to have open meeting rules. But we want to govern ourselves. We don't want to be controlled and be told that we're acting as a government and we have to follow their rules. Rich?
One of the primary things is that HOAs often want to take regulation of property so that they can frame an environment a little bit further than government does. And so if we were deemed government and government were limited, for example, in allowing certain properties to have a certain landscape scenario, it would be impossible for an HOA to go further than the government. So generally speaking, Karna's right. This is a philosophical issue that's very controversial, but currently the majority of those who weigh in at the Community Associations Institute level nationally have preferred to avoid being deemed a government entity.
Okay.
Yes.
So we're running out of time, but real quick, Michelle asked in regards to House Bill 2534, is the scope of the discrimination language the same as fair housing laws?
No, fair housing has a much broader scope. It's also federal. This discriminatory bill only applies to what is in your governing documents. Again, those could be rules, but it only applies to what's in your governing documents, and it requires you to, by a certain date, December 31st of 2022, I believe the date is, to go through your documents and either record a declaration saying that you've done the work and there are no discriminatory provisions, or to actually do an amendment to remove said discriminatory provisions. So the HUD rules on fair housing are much more substantial on prohibiting discrimination by HOAs.
Awesome.
And I saw